afternoon. I'm Sharon Van Sickle Robbins, City Club President, and I would like to welcome you all, those of you here at the Governor Hotel, and those of you listening on OPB or KBPS Radio, or watching on Portland Community Media's CityNet 30. Thank you for joining City Club today on Friday, September 17th, for our first debate of the fall season. In consideration of those sitting close to you and those in our radio and television audiences, I ask everyone in the room to please silence your cell phones. Today we will hear a debate about Ballot Measure 73, which would increase minimum sentences for certain repeated sex crimes and for repeatedly driving under the influence. I would like to start by welcoming City Club Membership Chair Sharon Brabenak to the stage for an important announcement.
Hello, I'm Membership Chair, Development Chair for our City Club. This is my second time as Membership Chair. I've been a member since 1993, and I look at the value of membership because I have a circle of friends for a lifetime. So, now is definitely the time to join City Club because we have a lot of votes coming up. So please join City Club today. We have our brochures on the table. You can check out our website, find out about all the other things we do besides Friday Forum. There's a host of activities in our city in various areas. So please join and have a great rest of your day. Thank you.
Thank you, Sharon. If there are any members who have joined City Club recently or who are here with us at a Friday Forum for the first time, would you please stand and let us welcome you? As always, we offer our appreciation to our Friday Forum corporate sponsors, whose generous financial support makes these City Club luncheons possible. Please join me in offering our sincere appreciation for our fall season sponsors, AARP Oregon, the law firm of Barron Liebman, the Confederated Tribes of the Grand Ronde, and PGE. If your company or firm would like to be a City Club sponsor, please contact City Club staff at the back of the room or call the City Club offices. In a moment, I will introduce our moderator, who will explain the rules of procedure for today's debate and introduce the debaters. But first, I want to remind us all that a key part of City Club's mission is to inform our members and our community regarding public issues. I mention this because we cannot achieve City Club's mission if we're not open to information and views that are different from our own personal opinions. As such, I would ask everyone in the room to remain courteous, respectful, and open to the information conveyed, even when you disagree with what you hear. By doing so, you will help further the kind of civic and civil discourse that City Club stands for, and you will honor our guest speakers, our own process, and the best interests of our community. And now to introduce our moderator. Judge Edward Jones was appointed to the Multnomah County Circuit Court in 1999. He's a graduate of Reed College and the Northwestern School of Law at Lewis and Clark College. After passing the bar in 1975, he spent 9 years in private practice in Oregon City and Portland, and 14 years as the director of MDI, a public defender office in Portland. He's the current chair of the Multnomah County Arbitration Commission. He's a past president of the Oregon Criminal Defense Lawyers Association and has served on the board of bar governors and the board of the Professional Liability Fund. Judge Jones?
Thanks for the opportunity to be here today. It's my privilege to moderate this debate on Ballot Measure 73 between Mr. Doug Harcleroad, an attorney with the Oregon Anti-Crime Alliance, who supports the measure, and Mr. David Rogers, the executive director of the Partnership for Safety and Justice, who opposes it. Ballot Measure 73 is a citizen initiative that increases the mandatory minimum prison sentences for offenders of certain sex crimes from a current minimum of just under 6 years to a new minimum of 25 years. In addition, it seeks to apply for the first time a 90-day mandatory minimum sentence for motorists repeatedly convicted of driving under the influence. Now, mandatory minimum sentences require judges to deliver fixed sentences to individuals convicted of a given crime with no possibility of a reduced sentence. Introduced in Oregon back in 1974 under Ballot Measure 11, mandatory minimums override Oregon's sentencing guidelines, which require judges to impose a sentence determined by a chart which provides a sentence based on the seriousness of the crime and the defendant's criminal history. Now, according to the state's official financial impact statement, Ballot Measure 73 will require the state to borrow $268 million to finance the cost of the first 4 years. The state will repay that plus interest of $203 million over the next 25 years. Now, proponents of Ballot Measure 73 claim that the increased sentences for these crimes are necessary to protect the public from dangerous repeat offenders and would act as an additional deterrent to criminal behavior. Opponents argue that such sentences will not be an effective deterrent and that such sentences that their high cost will divert resources better spent in other areas. Now, this debate will have several sections. First, each will give a 3-minute opening statement in an order that was determined by a coin flip, and Mr. Harcleroad won that coin flip. Following the opening statements, the debaters will respond to questions written in advance of this meeting by the City Club staff. These are the only questions that will be asked today. There will be no questions from the floor. We will rely on the judgment of our distinguished panel of City Club members seated at this table to my left, who will decide whether or not the debaters have actually answered the questions. If 2 or more of these 3 members raise their cards, I will restate the question and ask the debater to reply again. On our panel, we have Brianne Arnold, Ted Kay, and Jennifer Rollins. Keeping time of our debate is Tony Iacchino. He's right here. Following the City Club's questions, the debaters will have an opportunity to ask questions of each other, and depending on how much time we have remaining, they will get to ask 2 or 3 questions. At the end of that, they will get to do their closing statements. Now, I would ask you to be respectful, as I'm sure you will be, of our debaters, and hold your applause, laughter, derision as appropriate. Now, let me introduce the 2 debaters. First, and he will speak first, is Doug Harcleroad. He's an attorney offering public safety policy advice to the Oregon Anti-Crime Alliance. He had served as the Lane County District Attorney for 23 years, Doug, 25 years, something like that, where he prosecuted approximately 200 jury trials, including drunk driving cases, domestic violence cases, and major felonies. He also spent time as an adjunct professor at the University of Oregon School of Law, where he trained over 200 third-year law students to be trial attorneys in his course on prosecution. Doug also created a victim services program and was the driving force in the creation of the Child Advocacy Center, which provides a safe place for children to disclose physical and sexual abuse. In addition, it's his birthday today. If we have time, we'll sing happy birthday to him. Now, on the other side is David Rogers. He currently serves as the executive director of the Partnership for Safety and Justice, a statewide advocacy organization that works to make Oregon's approach to public safety more just and more effective. He also serves on the board, as the board co-chair of the Oregon Voice, a new statewide coalition that expands political engagement through collaboration between community and advocacy groups. He's been a consultant to the Ford Foundation and the People of Color in Philanthropy Network. He's also the recipient of the Charles Bannerman Fellowship for Organizers of Color from the New World Foundation. So as I step down to the moderator's table, let's welcome our debaters with our only permissible round of applause. All right, Mr. Harcleroad, your 3 minutes.
Thank you, and I appreciate the happy birthday applause. The first responsibility of government is to protect its citizens from harm. According to the National Institute for Justice for the and the Centers for Disease Control and Prevention, approximately 1 in 6 American women will be a victim of sexual assault in their lifetime. I'd suggest to you that government is not doing enough to protect us against the harm caused of sexual violence. The American Medical Association has called sexual assault a silent, violent epidemic in this country. Moving quickly on, the harm suffered by survivors of sexual assault is potentially catastrophic. I have a whole document all about all that statistics, but I only have 3 minutes. Turning now to repeat drunk drivers. Gretchen McKenzie, legislative analyst for the Governor's Advisory Committee on Driving Under the Influence, reports that 233 traffic fatalities in 2008 were alcohol or drug related in Oregon. That's a whopping 56% of our total of 416 traffic fatalities in that time frame. And it doesn't count the thousands of Oregonians that are injured every year by intoxicated, impaired drivers. The problems are significant. Let me take a step back now and just tell you that the Oregon Anti-Crime Alliance wants to make Oregon one of the 5 safest states in the country in terms of low crime rates, and that immediately triggers where are we now? And the answer is 27th in terms of index crime. We're not even the top half. Now, this measure, in the last 50 seconds, this measure only deals with repeat offenders. Let me say that again, repeat offenders. The Oregonian got it wrong. Repeat offenders for the most serious sex crimes we have. They're Class A felonies. These are the most serious felonies we have, short of murder, and not the first offense. And what our moderator said about the 6-year sentence, basically, that's for the first offense, not the second offense. 4 crimes. By the way, we have about 35 sex crimes. So when the Oregonian in their editorial said all sex crimes, it's not. 4 of them, the most serious. And it only deals with the 3rd drunk drive, which is really the 4th one, because most of the time, the first time you get a diversion, and I'm done at my 3 minutes.
All right, Mr. Rogers, your 3 minutes.
I want to thank the Portland City Club for providing an opportunity for me to speak about how Measure 73 is actually a dangerously bad idea and why Oregon voters should reject Measure 73. To be clear, we all want to be safe. We all drive on Oregon's roads and streets and live in Oregon's communities. We want to be safe. We want ourselves, our family, our friends, our neighbors, and our communities to be safe. The question is whether or not Measure 73 will make us safer. And the answer to that is no, it will not. It's actually a bad solution to serious problems. As we said before, my name is David Rogers and I work for Partnership for Safety and Justice. But today I'm actually speaking on behalf of a much larger coalition of organizations that have stepped up to oppose Measure 73. Organizations like the Oregon Education Association, the Human Services Coalition of Oregon, the Juvenile Rights Project, correction workers, addiction counselors, the Oregon Coalition Against Domestic and Sexual Violence, the Oregon Nurses Association, just to name several, have all joined together to oppose Measure 73 because it's a bad policy that won't make us safer. It may sound simple and look straightforward upon your first glance, but really it doesn't take much to identify the fact that Measure 73 is poorly written, seriously flawed, and has severe unintended consequences. To start with, it combines two problems: drunk driving and sexual assault. These are issues that have absolutely nothing to do with one another. And if we want to be effective in addressing them, we need to deal with them separately. Combining them in a poorly written measure, frankly, is just a cheap gimmick by the chief sponsor, Kevin Mannix, who is desperate for a political win. When you look at the organizations that work around sexual assault on a daily basis, organizations like the Oregon Coalition Against Domestic and Sexual Violence and many others, they are coming together to oppose Measure 73. Why? Because they know that Measure 73 will not only cost millions, but it actually diverts money and focus away from the very programs that prevent sexual assault. Frankly, Measure 73 is an unfunded mandate that will cost up to $60 million a budget cycle at a time when Oregon is in a difficult economic crisis. Measure 73 will divert funds away from schools, critical services to seniors, and healthcare. We can't afford it, which is one of the reasons why both gubernatorial candidates oppose Measure 73. Our coalition is asking and encouraging you to vote no on 73 as well. Thank you.
All right, thank you both. We'll now move to the part of the program where I'll ask questions prepared by the Friday Forum Committee and the City Club staff. The debaters have not seen these questions in advance. There'll be two kinds of questions during this debate. I will direct some questions to one debater. He'll have 60 seconds to respond. His opponent will then have 45 seconds to rebut. Other questions I will direct at both debaters, each of whom will have 60 seconds to respond. We encourage our debaters to use this abundance of time not only to offer their response, but also to offer a rebuttal to their opponents. Our first 4 questions will be directed questions followed by a question to both. So our first question will be for Mr. Harcleroad. And here it is. In 1994, voters passed Measure 11, which, for the first time in Oregon, mandated minimum sentences against perpetrators of certain crimes. Sentencing guidelines, on the other hand, which are still used for crimes not covered under Measure 11, set a presumptive sentence, but allowed judges to impose a greater or lesser sentence under certain circumstances. Why, in the case of sex and DUI offenders, are mandatory minimum sentences preferable to flexible sentencing guidelines?
The preference You all need to understand, before sentencing guidelines, which came in 1989, I testified about them at the Oregon. I teach about it or taught about it at the law school. Before those guidelines, judges had unfettered discretion, and they were packing the prison, and we were having to let them out the back door through the parole board. Sentencing guidelines came in. They built those guidelines based on how many prison beds we had, not on what the sentence should be. So I don't know how many of you women think that 4 years is enough for being forcibly raped, but I don't think so, and that's what those guidelines did, and there are lots of other examples I can't give you in a minute. So Measure 11 was a response to that when the legislature would not, I say would not, increase sentences under those guidelines. This targeted measure, well, I'm out of time, so if you
Can we
want
ask
to
our
put your
panel?
question mark up, go ahead and put your question mark up. Be all
I
three
think
of you
you've
ought
won
to.
another 45 seconds. The last part of the question is, why in the case of sex and DUI offenders are mandatory minimum sentences preferable to flexible sentencing guidelines?
Because you need swift and sure sanctions in this state where we actually know what's going to happen when somebody does something. Okay, so DUI, Washington, by the way, the state of Washington has swift and sure sanctions, 90 days for the second DUI offense plus electronic monitoring, and I don't have time to explain that to you either. So the reason we need mandatory sanctions is so it's consistent around the state, it's appropriate for those third-time DUI offenders. Regarding the sex cases, remember, these guys are raping, sodomizing, sexually penetrating with bottles, pencils, various tools, and we just need to put them away for a long time.
You're out of time again. Can I see the assessment? All right. Mr. Rogers, 45 seconds for your response.
Simply put, we actually don't need mandatory minimum sentences. Mandatory minimum sentences are a one-size-fits-all approach to sentencing, and they're a very bad idea. They tie the hands of judges. Right now, what we need to do for both drunk driving and sexual assault is we need to ensure that judges continue to have the ability to provide long sentences when it actually fits the crime. And we do not need a one-size-fits-all approach. It's worth mentioning that when Measure 11 was passed, it doubled the size of the prison population, it quadrupled the size of the prison budget, and we now spend more money on prisons than we do on higher education. That's mandatory minimum sentencing working, and I think that doesn't bode well for our future.
Can we see the? We don't answer on. Got it. All right. Next question. This one's going to be directed to Mr. Rogers. Measure 73 and mandatory sentencing in general seek to ensure that judges apply uniform sentences to criminals who commit similar crimes. Opponents of Measure 73 generally support greater judicial discretion in sentencing, but by giving judges the ability to hand down different sentences to similar criminals, isn't this advocating unequal treatment under the law?
No, absolutely not. When mandatory minimum sentences first appeared in Oregon in 1994, what we found was that there was a dramatic shift in the criminal justice system, and it moved power from judges out of the hands of judges into the hands of prosecutors. And I think it would be foolish for us to think that focusing on sentencing guidelines doesn't actually allow judges to provide long sentences, and that provides unequal justice. Right now, with mandatory minimum sentences, it provides a wide range of unequal sentencing practices that prosecutors have all the power in the situation. Right now, what we need to do is we need to move away from one-size-fits-all sentencing, and Measure 73 is exactly that. It's a bad solution for serious problems.
All right, Mr. Harcleroad, 45 seconds.
It's not one size fits all. That's just wrong. What it is it's a floor sentence that says when you do something particularly bad and wrong, and by the way, Measure 11 passed in '94 by the voters overwhelmingly. What that measure actually did was it set mandatory minimums for 16 crimes. The legislature has expanded that to 24, 25 crimes. And so it's not one size fits all. It's a floor that the judge cannot go below. And those floors, frankly, are lower than most of the states in the country. So that's just a misnomer, and you shouldn't think about it as one size fits all.
All right, our next question is back to Mr. Harcleroad. Mr. Harcleroad, roughly 90% of the state's general fund budget goes to education, human services, and public safety. Over the next 2 years, in order to balance the state budget, each of those areas will likely face significant cuts. The Oregon Secretary of State estimates that this measure would cost $268 million over its first 4 years. If this measure passes, what education, health care, or other public safety services would you cut in order to pay for it?
Mr. Moderator, $268 million is wrong. I don't know where you got that number, but it's wrong. I have the financial estimate right here, so I've got to correct the question. It's $1.4 million in the first year. It's $11.4 to $14.6 million in the second year, $13.9 to $21 million in the third year, $16.7 to $26.6 million in the fourth year. It's way under $100 million, way under. And we're working on a budget that's only 2 years, and that 2-year number is about $16 million. I actually have a way, if the legislature decides that this measure is less important. By the way, there's no cost for the sex offenders for 7 years, none, zero, zip, nada. That's what the financial report, it's only in the DUIs, and it's because they go to prison. This measure doesn't send them to prison. It gives them 90 days in jail. I could draft this in under a half an hour to make it so that it's 90 days in jail and they don't go to under sentencing guidelines to prison.
45 seconds, Mr. Rogers. Oh, 2 questions.
You asked me the question again. I thought I answered the damn thing.
The question is, well, where's the money going to come from?
Oh, okay. Whatever the dollar amount is, where's the money going to come from? Because it's clearly not $268 million. Please read the financial analysis that'll be in the voters' pamphlet. Well, here's what happens. The money comes out of the general fund. There's no question about that. Education gets 55% in round figures right now. Public safety, including the courts, gets 16.8% roughly right now. And social service gets the rest. So we're going to take it from somewhere else. One of those 3 places is where that money is going to come from. But it's not going to be that huge number, and I just gave you the solution for how to make it just a few $1 million. They did a Christmas tree bill for over $100 million in 2009. It's amazing.
All right, Mr. Rogers.
Measure 73 is clearly an unfunded mandate, and that's why there is such a large coalition of people who are opposing it and organizations who are opposing it. The state fiscal estimate is that when this is fully implemented, it will cost between $36 and $58 million a biennium. That is a serious problem, and it is actually a great deal of money, particularly when we're experiencing an economic recession and school funding, critical life-saving services are on the chopping block. We cannot afford Measure 73. And you know, what makes matters worse, why should we afford Measure 73 when it's actually not offering useful solutions that will make us safer?
All right, thank you. Our next question will be directed to Mr. Rogers first. How would you respond to the argument that you seem to be more interested in protecting criminals from excessive punishment than protecting potential victims from repeat offenders?
I think that that's a foolish assertion. You know, I mean, let's be clear. The people who work on a daily basis with sexual assault victims, whether it's the Oregon Coalition Against Domestic and Sexual Violence, the executive director of the Portland Women's Crisis Line, Bradley Engel, the domestic violence shelter here in Portland, Sexual Assault Support Services in Doug's very own home community of Eugene, are all opposing Measure 73, and they work with sexual assault survivors on a daily basis. This is not good for anyone in Oregon. What we need, you know, last year, over 19,000 requests for shelter from emergency violence went unmet because we are not funding victim services properly. And Measure 73 will make it more difficult for us to get critical services to victims. And that's one of the reasons why so many organizations are opposing Measure 73.
Mr. Harcleroad, 45 seconds.
Anybody in the room who would like to have one of their loved ones killed by a drunk driver, raise your hand. The answer is nobody in this room. This measure, if we put these people in prison or incarcerate them for 90 days, when it's the fourth time they've done this. By the way, I'm a treatment guy. I'm an alternatives guy. You look at my record as Lane County District Attorney, I created more alternative programs than I think anybody else in the state. Maybe Mike has done the same, drug courts, et cetera. All right. You put them in prison, we know incarceration works, we will have fewer dead people on the road, okay, regarding the drunk drivers. And if you put the sex offenders in prison for a long time, they will not hurt another child.
All right, our next question will be directed to Mr. Harcleroad. Prosecutors have significant discretion in how they choose to prosecute a particular offense. Under Measure 73, a prosecutor could use the threat of a long and certain prison sentence to compel a guilty plea to a lesser charge. This shifts sentencing power away from judges and toward prosecutors. Why is this a good idea, and what do you see as the consequence of this shift?
This measure is one small specific measure that deals with 5 crimes. What our moderator just described to you is what happens every day around this state, where prosecutors have great discretion to charge hundreds of thousands of cases. We did 100,000 cases when I was Lane County District Attorney, and we had that discretion. And this gives a little bit more discretion, but you know what? It's not nearly as significant. There are 5 guys on death row right now because I decided to try to kill them. Now, I don't use the words seek the death penalty. That's way too sanitary. There are 36 people in this state, they're district attorneys, who are authorized to seek legally death of somebody. So the fact that we're going to have mandatory minimum sentences, does it raise the bar in the negotiations? It sure does. What it says is that the harm that's caused by those particular crimes is very serious.
All right, Mr. Rogers, 45 seconds. Oh, sorry, 60 seconds on this one.
Measure 73 is a mandatory minimum sentencing scheme. And what we do know about mandatory minimum sentencing schemes is that they do create an imbalance in our criminal justice system. And it's a very serious imbalance that doesn't lend itself to justice being done. You know, right now what we need to do is we need to continue to allow judges to provide longer sentences when it's appropriate. We do not need, and I respectfully disagree, mandatory minimum sentences is a one-size-fits-all approach. It ties the hands of judges, it provides no discretion. Measure 73 would absolutely continue this kind of out of whack, out of balance approach that Oregon is taking. And really, we deserve better from our justice system. Oregon can and should do better.
All right, I now have a question for Mr. Harcleroad. Some repeat DUI offenders are functional drug or alcohol abusers. That's to say, they hold jobs, support families, and so on. Given the tough financial times that many families are facing, the stress to a child of having a parent in jail, and the lack of judicial discretion in cases where, for example, no one was injured by the offense, doesn't this measure risk doing more harm to the family of the perpetrator than the harm caused by the crime itself?
Yes, it does cause that risk. But let me tell you who it causes it for. It causes it for the 3rd conviction in 10 years, which is really their 4th drunk drive. So the way this actually goes in Oregon is the first time somebody gets arrested for driving under the influence of intoxicants, they get diversion. They plead guilty, they go through a whole bunch of treatment, they're there for a year, they're successful, they get off. No conviction. The second time they're on probation, Maybe short jail, maybe not, maybe community service. Instead, a fine and treatment. The next time, same thing happens again, more treatment. Same thing happens on the third one. It's the fourth one, which is the third conviction in 10 years, where now we're actually saying under this measure, look, there's accountability here. You're going to do 90 days in jail. And frankly, there are some negative impacts to that.
Mr. Rogers, 45 seconds.
There are a range of negative impacts, and Measure 73 will unquestionably be destructive on certain families. I mean, addiction is a very serious problem, and it has serious consequences, and drunk driving is one of them. But we know what works to break the cycle of crime, and what doesn't work is Measure 73. At this point, the Multnomah County Sheriff's Office released a report of 10 years of data on drunk driving, and we know that a single focus on increased prison time does not deter drunk driving. What does break the cycle is ensuring that people get access to court-supervised treatment. Measure 73 will make it harder for us to get people to the level, the treatment that actually breaks the cycle. And by the way, it actually will have a problematic impact on families.
All right. Next question for Mr. Rogers. By the time that Measure 73 applies to someone arrested for driving under the influence, they've already been convicted of this crime twice before. Supporters of 73 claim that the threat of a stiffer sentence will prevent people from repeatedly driving drunk. How would you respond to the family of someone killed by a drunk driver who's convinced their loved one would still be alive if the driver had known they would face jail time for a third conviction?
These crimes are very serious, and they need to be taken seriously. And, again, we all want to be safe. So really the question is, what are the policies that best make our roads and our streets safer? All of the research shows that if we're not getting people access to court-supervised treatment, we're not going to be breaking the cycle, and that's what's going to make us safer. It's also worth mentioning, though, that really, at this point, most Oregonians know that every Kevin Mannix-sponsored measure is not exactly what it seems. The 90-day mandatory minimum aspect to drunk driving is a ruse, because it actually felonizes that fourth offense. Actually, it's a third offense based on the measures written. That means actually people aren't getting 90 days. People are getting 13 to 14 months. And that's why this measure is so expensive. That level of incarceration is not only not helpful, that's why it costs upwards of $60 million and is an unfunded mandate.
Mr. Harcleroad, your 45 seconds.
The Century Council is paid for by the distillers, the people who put out the alcohol, and they don't want hardcore drunk drivers. And so they have a 146-page report on their website that talks about it. And here's their comment, I have one page of it with me, on certain punishment. When hardcore drunk drivers receive a lenient sentence, the deterrent effect of the laws is considerably weakened. And they cite a bunch of research above that comment. That's why the 90 days. It's swift, it's certain, it's not that long, and it will take care of that problem. If it's too expensive to put them in prison, we can change that in the next legislative session very easily. I can draft that with Legislative Council.
All right. Next question for both of you. First to Mr. Rogers and then Mr. Harcleroad. Under Measure 73, the 25-year mandatory minimum sentence for sex crimes could apply to minors age 15 and older, and multiple counts of transmitting sexual images could be considered prior criminal episodes. Given this, Measure 73 could be used to prosecute teenagers for sexting, the practice of sending other teenagers sexually explicit messages or photographs between mobile phones. Would you consider a 25-year sentence for a repeat juvenile sexter appropriate?
I thought you said Mr. Rogers, didn't he?
It is to Mr. Rogers first.
It is absolutely inappropriate. There are many people and organizations that are concerned that the kind of sloppy way that this has been written, that teenagers actually could be serving 25-year mandatory sentences for sexting. Let's be clear, youthful mistakes deserve consequences, but 25-year sentences for sexting is extreme and inappropriate. This is a fairly new social phenomena that we have. The Pew Research Center shows that 15% of every 12 to 17-year-old who has a cell phone is involved in sexting. We need to take a thoughtful approach to figuring out how it is we're working with young people to know that that's inappropriate. But to write a poorly written measure that has unintended consequences that could have teenagers looking at 25-year prison sentences for such circumstances is extreme, and Oregonians, I think, recognize that that's the wrong way.
Your 60 seconds, Mr. Harcleroad.
This will not happen. That's a ruse. It's nonsense. I've looked at the data for the last 4 years on this particular statute that's in this measure. I looked at the 15, 16, and 17-year-olds, and frankly, this statute was passed by the legislature. It's not a Measure 11 crime, although it has a mandatory minimum of 70 months right now. So if there's a sexting issue, it's there anyway on a first offense. Okay. I looked at the data, and what I can tell you is that 15, 16, and 17-year-olds, there were 2 convictions. I doubt they were sexting convictions, and there's never a second conviction in the OGEN data. That's the court data. So for the last 4 years, it would never have happened, a sexting charge like this. Now, the other thing is we know under the Rodriguez and the Buck cases that you can't have disproportionate sentences, and in a far less serious cases, sex abuse cases, the court said you can't have disproportionate sentences. The DAs know that. They will not be charging sexting with this crime. Won't happen.
All right, I now have some direct questions, one for Mr. Harcleroad and then one for Mr. Rogers. Mr. Harcleroad first. In Multnomah County, roughly 20% of those arrested for DUI are repeat offenders. The county's DUI Intensive Supervision Program, the DISP program, which judges offer as an alternative to incarceration for multiple DUI convictions, has only an 11% recidivism rate over the 10-year history of the program. Given this positive track record, how can you justify incarceration over treatment?
I know a little bit about that program, having heard Judge Bach, I think it is, testify about it. And here's the deal. That program should be used in the diversion mode. By the way, it's not the judge offering that, it's the district attorney offering that, because the district attorney has discretion to put those people in that or not. I like that program for first offenders, for diversion people. I like it for first offenders. I like it for second offenders. The third conviction in 10 years, it's time to have some real accountability because that program obviously didn't work for those people. Okay, it obviously didn't work for those people. Now, I don't know who that 11% is, and I don't know if they're second offenders, third offenders, or what, but it obviously didn't work for those people because they've done it again, they've been convicted again. And so, use the program on the front end. Use it the second time, use it the third time, but not on that third conviction.
45 seconds, Mr. Rogers.
Repeat offenders and repeat drunk drivers is a very serious problem. But I think what Oregon needs, we need research-based, evidence-based best practices if we're going to really create smart public safety policy that helps make our communities safer. The research clearly demonstrates that if we're increasing access to court-supervised treatment, that is what's going to break the cycle of crime. That's what's going to change the behavior of drunk drivers. Measure 73, there's nothing evidence-based or research-based about it. So it might make people feel good to throw drunk drivers in prison, but it's not going to change, it's not going to make our streets safer. Really what we need smart solutions. We don't need a lot of tough talk. Measure 73 is the wrong solution to a serious problem. Oregon deserves evidence-based, research-based solutions to our public safety policy.
All right, this next one is directed to Mr. Rogers. 3 of 4 sex crimes punishable under Measure 73 include the terrible crimes of rape, deviant sodomy, and unlawful sexual penetration. Moreover, to convict a sex predator under this measure, they must have been previously found guilty of a major felony sex crime. At what point do you concede that there are sexual psychopaths who cannot be rehabilitated and who must be locked up for as long as possible to protect the public?
I don't think anyone's going to argue that sexual assault isn't a very, very serious problem. I don't think that people are going to argue that there aren't predators and that incarceration plays a very serious role, and that there are people that we need to remove from society in order to create community safety. I think what's clear, though, is that if we're serious about addressing the issue of sexual assault, we need to listen to the people who are closest to that, who are the experts. And the folks who are working around sexual assault on a daily basis around the state oppose Measure 73, the Oregon Coalition Against Domestic and Sexual Violence, the Executive Director of Portland Women's Crisis Line, Saving Grace, which provides domestic and sexual assault services in Central Oregon, and again, in Doug's hometown of Eugene, the Sexual Assault Support Services, SAS, all oppose Measure 73 because it takes us in the wrong direction, and it will starve the state of funding and focus on the programs that actually prevent sexual assault.
Mr. Harcleroad, 45 seconds.
I expect that the reason that those folks are opposing this measure is because of the cost, although I have not talked to them. Let me just tell you that the Oregon Criminal Justice Commission, in their 2007 report to the legislature, here's what they reported about incarceration and what it does for us as a community. Recent research indicates that incarceration significantly affects crime rates. And what we know is that our crime rate rose 690%, 691% in violent crime. And it's now gone way down since we had more incarceration. And the other thing they say is that for every dollar we spend on incarceration of violent criminals, we save $4. Sounds like a good deal, doesn't it?
All right, I have a final question that I'm going to give you each a chance to answer. And here is that question. Why are sex crimes and driving under the influence, which are very different kinds of crimes, combined into a single ballot measure? If I think we should definitely have higher mandatory minimum sentences for one, but not for the other, how should I vote? Mr. Harcleroad.
Well, I'd vote for both. Obviously, I vote for it. But you need to understand why these are linked together, all right? It's because it's targeted, and Kevin Mannix did this a long time ago. You got to remember, a couple of years ago, the economy was a lot different, but he targeted repeat offenders. He said, that's where we're weak. We need to target repeat offenders. And it's only for 4 sex crimes and the 3rd DUII. So the common thread through both of these measures is repeat offenses. And they're all person crimes, by the way, under Oregon law. So if you like one but you don't like the other, I would encourage you to analyze closely why you don't like the one that you don't like. You might think 25 years is too long. Let me just tell you, having worked with these children and established a center for these kids, it's not too long. Not too long. These are lifetime harms that occur.
Mr. Rogers, your 60 seconds. Oh.
I get 2 questions. You asked me the question again.
All right. The question is, why combine these 2 measures?
The question is, if you agree with one and not the other, how should you vote?
Right. If you agree with one...
I answered that in the beginning. I said vote for it, I thought.
All right. Mr. Rogers.
You know, I think it's an excellent question, and people around the state, I think, have been asking that very question and honestly scratching their heads. You know, combining drunk driving and sexual offenses, these are 2 problems that have absolutely nothing to do with one another. And it's a really bad approach to public safety policy. And, you know, honestly, just to be frank, I think it's a cheap gimmick by the chief sponsor, Kevin Mannix, to trick voters. He really needs a political victory. And I think it's playing on the politics of fear. my advice to people who would like maybe like one component but not another is to not support it. This is bad policy. And really, if we want effective solutions, we should be looking at each problem separately and identifying the most effective research-based best practice to deal with the problem.
All right, thank you. We're now going to give the two debaters an opportunity to ask each other questions. We'll only have time for two. They have to ask their questions within 30 seconds, and the opposing debater will have 1 minute to respond, and the questioner will have the option of a 30-minute rebuttal. We'll alternate between the debaters. We'll start with Mr. Harcleroad.
Mr. Rogers, what statutory scheme have you folks had prepared for this legislature that's going to deal with the problem of repeat drunk drivers?
Well, you know, I'm really glad that you asked that question, because one of the things that we've been working on closely with addiction counselors and treatment providers and other people who are really concerned about community safety is to work on ensuring that Oregon is adequately funding, first of all, our addiction treatment infrastructure. Because if we're serious about addressing drunk driving, we need to invest more money in addiction treatment. And by the way, it's not only proven to reduce crime and drunk driving, but it's a great return on our investment, and it saves dollars, tax dollars in the process. We're also trying to figure out how it is we can advocate for increased funding for programs like DISP, the Multnomah County-based program that is proven to be effective at breaking the cycle of crime and drunk driving. You know, this is a difficult task to increase funding for these critical programs because we are actually in a difficult situation looking at a multi-billion-dollar deficit. But ultimately, if we're investing in programs that reduce future crime and save money in the process, that's a much smarter investment than Measure 73, which is an unfunded mandate.
Want to exercise your 30-second rebuttal?
I think the answer that he gave was none. They don't have any legislative things put together, and he just talked in general about it.
Mr. Rogers, question from you.
So during the explanatory committee process coordinated by the Secretary of State's office, Kevin Mannix, the chief petitioner of Measure 73, indicated clearly and publicly that he never intended to have the provisions of Measure 73 apply to 15, 16, and 17-year-olds. I'd actually really like to know why your group continued to move forward with the measure even after acknowledging such a significant mistake that includes juveniles.
That's a pretty easy answer. District attorneys have discretion to prosecute 15, 16, and 17-year-olds under Measure 11 now, and they've had it under the pornography statute as well. And they've had it under all four of these sex crimes that are listed in this measure. They've had it since 1994. So this measure actually just leaves the law the way it was regarding who it applies to. District attorneys, back in 94, I know I was one back then, in 95, when we started implementing Measure 11, set up procedures to screen those cases. I know in my office, the statistics after the first 2 years showed that those individuals arrested for those Measure 11 crimes, 56% of them, we left them at the juvenile department. We told the police, take them straight to juvenile, don't be bringing them to the jail. And other district attorneys around the state did similar things. So it's a screening that occurs.
All right. You want your 30 seconds?
Absolutely. You know, honestly, I think it's irresponsible. I think Oregon voters deserve better. We want people to craft smart, thoughtful ballot measures before they bring them to Oregon voters. And to acknowledge such glaring mistakes and to move forward anyways is really, Oregon deserves better. And I'm worried, deeply worried about how teenagers could be caught up based on the unintended consequences and the poorly way that this is crafted.
All right. Mr. Harcleroad, do you have another question for Mr. Rogers?
No.
Mr. Rogers, do you have another question for Mr. Harcleroad?
Yes, I think that there's a recurring theme, but I want to put it out nonetheless. You know, sexual assault is a very serious problem. And the real experts that work on this on a daily basis every day are opposing Measure 73. I've mentioned the organizational names several times before. I won't do it again. But I'm wondering why, if the leading anti-violence advocates in this state are opposing Measure 73, why do you think it's a viable solution? Or why are they opposing it?
Well, you need to ask them if you want to know why they're opposing it. I suspect it's because of cost. And as to why I think it actually works, it's repeat offenders. The Criminal Justice Commission has determined that it's about 13 offenders a year, really a very small subset of the sex offenses. There are literally thousands of sex offenses every year. There are over 35 sex crimes, all the way from public indecency to the most serious. This only deals with the most serious, and it only deals with it the second time they do it. It's their second conviction. And so what I know is that incarceration does work. I gave you one statistic from the Oregon Criminal Justice Commission, and frankly, if we lock somebody up for 25 years, which is a very long time, but it's only because they did such horrendous acts more than once, and it will make them so they don't do it again.
30 seconds, Mr. Rogers.
You know, Measure 73 is deeply problematic. It was poorly written, has unintended consequences, it's an unfunded mandate. I think that it really was put together in an unthoughtful way, and repeat offenders are a very serious problem, but it's offering the wrong solutions to that problem.
All right, we now are going to our closing statements. Each speaker gets 3 minutes. We'll start with Mr. Harcleroad.
I want to take you back to 1986. Then my 5-year-old son and I were in a pickup truck. We had gone to our old house. I'd borrowed the truck from a friend to haul some firewood to our new home. We're going by Lane Community College on a Sunday afternoon at 4:30, when all of a sudden I am hit in the rear. Our pickup truck is sent across 2 freeway lanes, in essence. Fortunately, there were no oncoming cars. We bounced through a ditch. About 400 feet later, I stopped that truck, thank God, right before this huge tree. Cops were called. My wife was called. She was crying when she saw this truck out there in the field. My son ended up with a concussion out of that case. I ended up with a neck injury that lasted over a year. Lots and lots of physical therapy. By the way, I'm now a believer of whiplash if any of you need an expert witness. There was a lot of pain. That was Ermeline Dotson's first conviction for driving under the influence of intoxicants, and she also had marijuana in her system. I was okay with the 10 days she got in jail for that sentence. We obviously had a special prosecutor come in. And the probation. Had Ermeline done that again on a simple drive under the influence without rear-ending somebody else, I would have been okay with her getting a little more jail time and one more time for treatment. But you know what? On the 3rd time when Ermeline did that, if she did it again, it was time. It was time for her to get a significant sanction in jail, the 90 days. And frankly, it wouldn't bother me if Ermeline went to prison for 13 or 14 months. And she had children. It was a tragedy as that happened. Thank God she was driving her mother's car and it was insured. Well, let me tell you, that story that I'm one of the lucky ones. There are a whole lot of unlucky people. Why? Why should we tolerate 3rd-time drunk drivers not doing a fairly short sentence in either jail or prison? We shouldn't. Okay. So that's my story about driving under the influence and that 3rd conviction and why we need this bill, or this initiative. Now let's talk about the sex offenses. Let's talk about the sex offenses. I have dealt with these children, 13, 14-year-olds, who have been assaulted in terrible ways. The second time they do that, they deserve to go to prison for a long time. That's all there is to it. So vote for this measure. Thank you.
Your 3 minutes, Mr. Rogers.
I want to again thank the Portland City Club for providing an opportunity to have a substantive debate on Measure 73. I hope this debate revealed that ballot measures like 73 are oftentimes much more complicated than they first appear. And when you dig a little deeper, we recognize that Measure 73 will be very bad for Oregon. Oregon voters absolutely need to look beneath the surface. We'll find that this measure is poorly crafted, it has severely unintended consequences, and it's an unfunded mandate that we can't afford. When newspapers now around the state are beginning to look a little deeper, they're taking strong positions in opposition, whether that's the Oregonian to the Klamath Falls. To be clear, we all want to be safe. We want ourselves, our family, our friends, our communities to be safe. It's really a question of what's the best public safety policy that's going to make our communities safer. Measure 73 will not do that. It will not make us safer. It's the wrong solution to serious problems. That's why a wide range of organizations have come together to step up and oppose Measure 73. Whether it's the Oregon Education Association, the Juvenile Rights Project, the Human Services Coalition of Oregon, the Oregon Alliance for Retired Americans, correction workers, addiction counselors, the Oregon Coalition Against Domestic and Sexual Violence, and many others all oppose Measure 73 because it's the wrong solution and there are very serious concerns. It combines two issues that are completely different, that need to be dealt with separately, which is really just a cheap gimmick by Kevin Mannix, who is playing on the politics of fear to win a political victory at the ballot box. The individuals and organizations who are closest to the issue of sexual assault, who are working tirelessly around this issue on a daily basis, oppose Measure 73 because they recognize it will cost millions and it will divert both money and focus away from the very programs that actually prevent sexual assault and provide life-saving services to victims. There are a range of unintended consequences, including how teenagers could be caught up with 25-year mandatory sentences for sexting. That's extreme, and it was a mistake by the sponsor of the measure, and he's moving forward anyways, which is honestly irresponsible. Oregon voters deserve better. To make matters worse, we are in an economic recession and crisis. School funding for senior services and healthcare is in jeopardy, and this is going to cost upwards of $60 million a budget cycle. We cannot afford that. That is why both gubernatorial candidates oppose Measure 73. The coalition that I'm working with wants to encourage you to join us in voting no on Measure 73. Thank you.
All right, thank you both. That wraps up our forum for today. As the president returns to the stage, let's give our debaters a big round of applause.
I want to thank again our Truth Squad members, Brianne Arnold, Ted Kay, and Jennifer Rollins. Thank you also to our timekeeper, Tony Icarino, and a special thank you to our moderator, Judge Edward Jones. And of course, our greatest appreciation to our two debaters, Doug Harcleroad and David Rogers. Please join us again next week for a debate about Ballot Measure 75, which authorizes a gaming tax on an as-of-yet unauthorized private casino. We're adjourned.